Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Eastern Caribbean Supreme Court, St. Lucia, hearing of appeal in CCJ Appeal LCCR number 1 of 2024 between Marius Wilson and the King. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge, Madam Justice Rajnath Lee, Mr. Justice Barrow, Mr. Justice Burgess, and Mr. Justice Jamadar. May we have the appearances, please? Thank you.
Yes. May it please you, Your Honors. My name is Alberton Richlow. I'm appearing on behalf of the appellant in this matter. In association with me is Ms. Alberta Richlow. Appearing for the respondent is Ms. Kelly Thompson, Deputy Director of Public Prosecutions in St. Lucia, along with Mr. Linton Robinson. May it please you, my lords. May it please you, Your Honor, the appellant is physically present with us here today. Thank you.
And good morning to Council. Are you ready, Mr. Richard?
Yes, please, sir. If it may please Your Honors, this is an appeal emanating from the Eastern Caribbean Supreme Court from the jurisdiction of St. Lucia. In this appeal, may it please you, Lord, arises out of certain facts which I've just outlined before I proceed to the issues arising in this matter. This was a case in which the appellant, on the 7th of June 2012, allegedly shot a virtual complainant who I will refer to as pointed out in the judgment of the Court of Appeal as Winsworth. The appellant...
Mr. Rishley, just a little curiosity. Why do you say allegedly?
Well, I'll get to that when I...
But he said that you shot him in self-defense.
Yes, please, certainly.
It can't be allegedly. Come on.
Oh, as a matter of fact, I think I'm a little mistaken because I think that I'm too accustomed to the lower court.
I see. Okay, there we go.
So I have been, yes, and that he shot the virtual complainant. He was charged for causing dangerous harm and using a fire with intent to cause grievous bodily harm. The matter went to trial before Justice Thompson in this matter, and in an unfortunate turn of events, the appellant, the witnesses, at least 4 of the witnesses for the prosecution turned hostile, except for one witness who pointed out, with nothing more, nothing less, who shot Winsworth? Marius Wilson shot Winsworth, meaning the appellant shot Winsworth. Against
Wait,
that,
were you in the trial?
excuse me, sir?
Were you counsel at the trial?
And forgive me, I am extremely curious as to the compilation of the record of appeal. I do not see the testimony of the witnesses. And in particular, since you are going to make some capital of it, the evidence of Rita DeMar, I think, would have been instructive for us to see how scant or how adequate it was. Is it in the record?
I'd be interested to know as well if counsel for the prosecution have copies of the notes of evidence of the witnesses.
And all of those notes were filed with us?
But those are not with us. Okay. Curious, very, very curious.
But how can we assess an appeal if we don't have all the notes of the evidence?
Just to further that discomfort, the matter, for instance, of the no case submission, we don't have any record of that.
All that I have seen, counsel, is the summation.
It's too late to do anything about it now, but just to draw to your attention as a seasoned campaigner, how unsatisfactory this is.
Yes, I certainly do agree, Your Honor, but I am flabbergasted because I really and honestly believe that this was part and parcel.
Well, I'm glad we're both at a loss. Do continue.
But Miss, is it Thompson? You said you have the bundle with the notes of evidence,
We do indeed, Your Honor.
and that's the entire transcript of what took place at the trial court.
That is correct, Your Honor.
Do you have it electronically?
We do not have it. I believe I might have an electronic copy actually on my device, Your Honor. So I may be in a position to email it to the Honorable Court if that could assist. Alternatively, we are in a position to display it if this court so desires.
Well, both. We certainly would want to have it filed at some point, well, as soon as practicable.
So file in the proper format, the portal, etc. Yeah?
Yes,
Okay.
I can actually do that, Your Honor.
Okay, great. Mr. Richelieu, that would be acceptable to you?
Yes, please.
Good.
Please, Your Honor.
Does this Honorable Court wish for me to do that right now? Attempt to do that?
No, you don't need to do it right away.
I'm guided, Your Honor.
Yes, Mr. Richelieu, please
Yes.
continue.
And so, my lords, the issue which arose as a result of the trial, the appellant was convicted. And the appellant appealed to the Eastern Caribbean Supreme Court of Appeal, and the appeal was dismissed in that the court did not accept the arguments in relation to the question as to the direction of hostile witnesses. And at this point, we are respectfully submitting to you, as it were, that the learned trial judge erred in terms of his directions on hostile witnesses, and the Court of Appeal, we are respectfully submitting, was wrong and in that regard, my lord,
Sorry, did the appellant serve his time?
as a matter of fact, yes, my lord.
Okay,
What happened was that he was sentenced to 5 years.
right.
And
Reduced.
And the Court of Appeal allowed the appeal on sentence, and it was reduced to 2 years.
Right. And he has served that time.
Yes, please, my lord.
I see. Continue.
Yes, please.
Just a detail. Thanks. And you're saying the Court of Appeal was wrong in relation to the direction on hostile witnesses, and the trial judge, you're saying, erred in what way?
We are respectfully submitting that the trial judge erred in that in relation to the hostile witnesses, may it please you, my lord, and I am not sure whether your lordship, sorry.
That's okay, that's fine.
I am not too sure whether your honors have my written submissions to the Court of Appeal as part of the record.
I don't remember.
We have your written submissions to us.
Excuse me, sir?
We have the written submissions to this court. You filed submissions before this court.
Yes, I am aware, sir. So I'm just asking that if,
We have your written submissions that you filed before us.
yes, okay. And so, in that regard, we are respectfully submitting that,
Sorry, Mr. Richley, I see on the list that you filed that the written submissions to Court of Appeal, appellant and respondent are stated to be on the record at 231 to 283 of what you filed
Yes,
then.
please, ma'am.
Yeah? So the page number is not in accordance with the CCJ's page number, but I guess internally they can be found. So thanks. So we still are waiting to hear what is the error
yes, please, sir.
that the
I'm
trial
getting-
judge made.
At right. May it please be noted, Your Honors, in the direction of hostile witnesses, I would just like to address your honors to page 241 of the record.
Sorry, which record? The the CCJ's record? The CCJ's record appears in blue ink at the top of the pages.
Yes. Yes, that is 231. It starts from 232 of 284, which is the,
232
yes, the 234.
of 284. Okay.
And
Summarize for us what was the error?
well,
One sentence.
In essence, what we were saying is that all of the witnesses, the witnesses who gave evidence and were treated as hostile,
Right.
all of these witnesses disavowed themselves of the statements which they had made to the police.
Right. We are clear on that.
Right. And in those circumstances, the London trial judge at that point in time, after having said that the statements out of court is of no evidential value, he went on further to state in his words that he said, now the other direction I must give you is in respect of hostile witnesses. I ask you to pay close attention to this directive. Now, these witnesses have given an account in their statements which were given at a time when the events were fresher in their memory in the witness box. They told you that they could not recall events that were in statements that they read, although they read it the Wednesday and Thursday before, just before the case. That is Corinthia and Leonie Alexander. They were not asked about which version of the events was true, that is, whether the statement was true as to what happened. No one asked them what was the truth. Your task is therefore to decide whether these witnesses are unable to recall the events, in which case you may decide that the evidence is completely unreliable and worthless. Alternatively, you may form the view that the statement in which they recall the events of 7th of June represents their recollection at the time when the events were fresher in their mind. We are respectfully submitting.
Were the statements tendered?
No, sir.
They were
No,
not
no,
tendered.
Miller. No, Your Honor.
So the statements were never before the court.
They were never before the court.
So what evidence was before the court?
The evidence that was before the court was that I could not remember.
Right. So they went into the box.
Yes.
They were treated as hostile witnesses,
Yes.
and the evidence they gave was simply evidence saying what?
My name, my occupation,
Yes.
and I cannot remember.
No statement was put in. Their earlier statements were not tendered or put before the court.
No, my lord, because
Right. Oh, no, no,
Others-
no, no.
sorry.
That's my own appreciation of it. I just want to be clear about that. So the jury only had their testimony that they gave in court. Right. Good, no, fair enough.
Lonnie Alexander was one of those,
yes, Your Honor.
but didn't she say that she didn't see Winsbert Alexander with anything in his hand?
Richard Dimar.
Lonnie Alexander didn't give that evidence as well?
Leonie Alexander, from what I can recall, said that she said that she did not see the virtual complainant with anything in his hand.
Were the witnesses cross-examined? These are prosecution witnesses, right? So they gave the evidence you said. Were they questioned? Did you question them?
No, Your Honor.
You asked them nothing.
I asked them nothing.
That's the 4 or 5, right? 4 of the witnesses were hostile. 4 of the 5 were deemed hostile.
Yes, 4.
Right. Okay.
And the non-hostile one, you asked one scintillating question.
About the lighting condition.
Yes.
Right.
And like a good cross-examiner, you knew where you wanted to stop.
Is it?
Like a good cross-examiner, you knew where you wanted to stop.
Yes, Your Honor.
Okay, good. So that was it.
And that was it.
Yes.
So the witness who gave evidence, I forget her name now. That's the
Rita
common law-
DeMar.
Right.
Richard Dimar.
Right. Her evidence was the evidence that the jury had from the prosecution side,
Yes, Your Honor.
right? Subject to the answer to your question about lighting conditions.
Yes, Your Honor.
Right. Okay, good.
So our contention is that we are respectfully submitting that when we look at paragraph 46 to 47 of the Court of Appeal decision,
You didn't tell us what was wrong with the direction, on hostile witnesses. You had started telling us that you are critiquing the judge's direction on hostile witnesses. You remember that? And then we went off on a little, apologies, we took you off on a little bit of a digression. What, and our brother asked you if you could summarize in a sentence or two, what is the criticism of the direction in relation to hostile witnesses?
the criticism in relation to the direction, it is, Your Honor, is that the direction, and let me, if I could just preface it, in a situation with hostile witnesses,
Mr. Fishley, I think, and see if I get you right, your criticism is that the judge did not tell the jury that none of these witnesses gave any evidence incriminating the accused.
that is my submission, Millard.
Uh-huh.
Yes,
That's what you're saying.
that is what I'm saying, Millard.
So you're reading the passage from the judge where he said, on the one hand, if they said nothing, then that is the end of it. But if on the other hand, they said something, then you can accept it. You are saying that was wrong because they said nothing, and therefore he should have told them that they said nothing, and therefore you cannot rely on them for anything. That's it?
That is properly put.
Good, thanks. I'm grateful.
That,
But what were they going to weigh? If in fact they said nothing, which you have agreed, except their names and addresses, and the judge tells them, you have to assess what they say, and the witness statements were never put in, what evidence did the jury have before it? From them? Nothing, is that right?
that is correct, according to the authorities, 0.
Anything incriminating?
Nothing incriminating.
So if the judge tells them they must weigh what they have, what were they going to I'm struggling to find out what to see. I hear what my brother has summarized as your position, but I don't see what is the prejudice, what was the unfairness. All that the judge said is, you see them, you hear them, weigh what they have to say. If they have said something, consider it. What were they going to consider? How is that prejudicial or unfair?
If I'm permitted,
Yeah. You remember we looking at the summation in the context of the facts of the case, what happened in court.
yes.
This is not an academic exercise.
No, it is not.
No, all right.
It is not, my lord. But if we just if you may bear. When I'm considering the defendant's, the appellant's defense, the learned trial judge said, and I'm just trying to find it, where he said, so of course, where the appellant's defense was being considered, the learned trial judge went on to say, so of course, the evidence of this bad blood does not mean that Winsbot's evidence is untrue or that Winsbot attacked the defendant. That is what we're taking issue with.
But who gave evidence of bad blood?
The defendant.
All right. So the defendant chooses to talk about bad blood.
Yes,
The hostile witnesses say nothing of any evidential value. We know that much. The accused volunteers evidence about bad blood. What direction should the jury give about that? What is the flaw in the direction given that the accused introduced that evidence?
the flaw in that direction, I will respectfully submit, is when the learned judge says that it does not mean that Winsbot evidence is untrue, when in fact there was no evidence emanating from Winsbot of any probative significance.
So what was the jury going to weigh in their mind from the witness?
The only thing they could have weighed, may it please the Lord, is what the defendant said. Is what the appellant said. There's nothing else to weigh.
So when the judge says it doesn't mean that what the witness said is untrue. All the witness said is, this is my name and this is where I live.
Yes.
So in other words, if there's bad blood, it doesn't mean that the evidence about name and address is untrue. Is that the practical effect of the summation, of the direction?
In my respectful submission, I would not say so, my lord. What I would say, the evidence that Winsbot gave is evidence in relation to, he gave nothing at all.
But that's the point.
Right. He gave nothing of any significance. What the appellant said is in relation to bad blood. Winsbot never gave evidence in relation to bad blood. But it would be, I cannot see following logically that there was any evidence given by Winsbot which could have been untrue.
So, Mr. Richelieu, it is simply that it was a gratuitous direction on the part of the judge.
My lord,
No, listen to what I said.
yes.
The direction on the part of the judge on your formulation was gratuitous. It does not mean, the judge said, that Winsbert's evidence is untrue. Winsbert gave no evidence. Therefore, there is not anything to be true or untrue. Therefore, the judge's direction was gratuitous. It served no purpose. It could not affect positively or negatively their reception, the jury's reception of Winsbert's evidence.
And so therefore, my Lord, Your Honor,
How is it prejudicial then? How has it undermined the fair process of the trial? If the effect of the direction, it has no effect because there was no evidence. If Winsbert had said something that in some form or fashion implicated the accused, yes, then maybe we can consider that this could be prejudicial. But what you have said to us, and we've covered this ground, is that some effect of the evidence is zero. So the judge saying weight in the scales amounts to what? What possible evidence could a jury have taken from this witness that was prejudicial to the accused?
it may very well have led to, it could have given the impression, as it were, as I stated in
That this witness was a truthful witness.
that is it.
But truthful about what?
No, not
About name and address.
no, my Lord,
And about not remembering what took place tonight.
I think that, let me see if I could start
Yes.
from
Help us.
there you have witnesses giving evidence, supposed to give evidence. Unfortunate turn of events. So we can put it this way, that the evidence is of no probative significance of the appellant's guilt. The Liller trial judge went on further to inform the jury, well, don't worry about these witnesses. The statements that they have given no evidence, but the statements that they made to the police, you'd have to consider.
No,
No.
He told them that those statements are not evidence. If they had been evidence, they would have been produced in the trial. He said that explicitly. Come on.
You know, I think that we, honors that we are a little across purposes. What the learned trial judge, if I understood his language.
Mr. Richard, please stay closer to the microphone.
Oh, sorry,
It
sorry,
helps with the
sorry.
recording.
Let me get the,
Mr. Richard, looking at the summation, I can't recall what page, because I think the page I have is from your application for special leave.
yes,
But I see that the judge, in dealing with hostile witnesses, said at summation page 20, perhaps I better put it that way, it might be the same. He said their answers were that they could not recall.
yes,
And that is what matters.
yes.
That is what the judge says. The judge goes on to say, perhaps this is what you were alluding to. You, of course, will decide whether they could genuinely recall events. And you will decide what you believe and what facts you find in keeping with directions that I will come on to give you next, right? That is how the judge put it. So I take it that has to be looked at in the full context of the directions that came later on. But certainly the judge was making it clear that their answers were that they could not recall, and that is what matters.
Further, the Court of Appeal, I think at paragraph 46 of the judgment,
Yes, let me,
accepts,
yes,
paragraph 46, it's at page 28 of the CCG record. I think the Court of Appeal was
Paragraph 46, mate?
paragraph 46.
Yes.
Was a little sympathetic to the argument that the judge may not have sufficiently tailored the evidence or the lack of evidence to the judge's directions. The judge says, frankly, the evidence of the hostile witnesses lacked any meaningful probative value relative to the guilt in the middle of the page, relative to the guilt of the appellant. And the trial judge should have made this clear to the jury. It does appear, therefore, that there is some merit in the criticism that the judge did not tailor the directions to suit the circumstances of the case. In tailoring the directions, it would have been pertinent for the judge to consider that this was not a case where the hostile witnesses accepted any of the parts of their statements that were incriminatory of the appellant. They disavowed any recollection of them. At the same time, and this is the point my brother Justice Chamada has been making, nothing said by them in their evidence exonerated the appellant. They did not say, for example, that someone else shot Winsworth or that Winsworth was acting menacingly towards the appellant. Those parts of their statements that they did accept were of negligible value, as the appellant was not denying being present at the club and shooting Winsworth. So the Court of Appeal seemed to have accepted that the judge could have been more nuanced, could have been a little bit more accurate in tailoring the directions to suit the circumstances. But at the end of the day, there really wasn't anything said by them that could have affected the fairness of the trial and your client's case.
I accept that. As a matter of fact, that was part of the argument that I was going to advance. In that, my contention was that, and when I was stopped by the court, by this honorable court, that I was pointing out that when it comes to hostile witnesses, there are varying circumstances in relation to the hostile witnesses which may exist. And that, for instance, you may have a hostile witness who provides no evidence at all. You may have a hostile witness who would say something contradictory, directly contradictory to a statement that they made, which would assist the defendant. And so therefore, that is why that over time, with cases like Moore and the cases that come after, that directions developed which were tailored to suit the particular facts and circumstances of a case. For instance, in a case where whatever the witness said.
We understand that, and let us accept, I think we all can, that this was a sort of a generic direction, not tailored. Your preference is the judge should simply have said explicitly that none of these witnesses gave any incriminative evidence and the evidence lacked any probative value. Full stop.
Yes, Miller.
Right. If
Yes,
the judge had said that, you would have no complaint. Agreed?
Yes, I agree.
Good. But the judge went on to give what I call a more generic hostile witness summation and said other things. But must we not, how do we test it? Let us accept, as the Court of Appeal, like the President has brought to our attention, the Court of Appeal had recognized that it was not as nuanced as it should be. But how do we test it in this appeal? Do we not have to ask ourselves whether the effect of this summing up on the minds of the jury could have had a potentially prejudicial or unfair effect? Would you agree that that is how we have to test whether this particular summing up crosses a permissible or impermissible threshold?
That I do agree.
You agree with that?
I do agree.
All right. Okay. So that's what we have to ask
That
and
is
answer.
correct.
Okay.
But at the same time, Your Honors,
Mr. Richland, I don't want to stop you. I just want to point out that you're well into your allotted time, so you just have to decide how much more time you want to spend on this. Continue to spend as much time as you want, just drawing to your attention. Yeah?
Your Honor, as well,
How you would sum up in 2 or 3 sentences your submission on this point and then move on to the next one?
yes. Inasmuch as this honorable court is indicating that, of course, the test is whether or not whether that particular pronouncement made by the trial judge in the summing up was likely to prejudice. Inasmuch as I accept that, of course, the fact that the Winsbot's evidence had no probative significance, but at the same time, it is my humble submission that failing to have given the clear direction I wish to respectfully submit in relation to Winsbot, that it had no probative significance. My respective submission is that the mention of the word evidence, whether it was true or untrue, was likely to prejudice I wish to respectfully submit, the defense of the appellant being placed before the jury. And I think I will stop at this point, and then I'll move on to my next point.
Yes.
So that is the...
Remember, stay by the microphone.
Oh, sorry.
Yeah. Okay. Yeah.
My lord, I'd ask you all to excuse me, and I must be apologetic because it's the first time that
That's
I think
fine,
I'm
that's
holding in between two pillars in order to make a delivery.
Okay.
Move along, Mr. Richley.
Thank you. Now, the next grounds, with all due respects, now I wish to move to the question of the good character direction. May it please, ma'am. That's right. Yes, I wish to respectfully submit, my lord, your honors, that although the learned trial judge gave the full direction, good character direction, to the jury, our complaint is that in the manner in which he did it, despite, in a way, of speaking both of the credibility and the propensity limb, he appears to have given that direction. Or in fact, not appears, he gave the direction. But we are respectfully submitting, my lord, that the direction was diluted in two ways. I would first address your honors in relation to pages 200 of the CCJ record of appeal in which the summation appeared.
Is there a small number at the top of your document?
Yes, ma'am.
Counsel, just tell me
Yes,
what
Your
that-
Honor.
what that page is.
Page 18.
Thank you. 1/8?
Yes, please.
Thank you.
Yes, please. It's at lines 20 to 25.
Thank you.
What is that page or what page is it? Oh, oh, oh.
Mr. Speaker, if your junior has the pages and you put it under the, then we'll see it also. Right, there you go, right? So that if you put it there, that's right. So if you just put it there, we will also see it on our screens in the same way you see it on your screen. So when you come to the actual passage, if you just put the page underneath there, we see it at the same time. Okay, thanks. Yeah.
I'm wondering if whether your honors have the passage I intended to.
Page 200, you
lines
said?
20 to 25.
Yes, that's what you told us, lines 20 to 25.
Yes. Now, one would observe at that page, your honors, then the trial judge had this to say about the good character direction. Finally, having regard to what you know about this defendant, and in particular, the 9 years since the date of the alleged offense, and that no similar allegation has been made against him, you may think he's entitled to ask you to give whatever weight you think fit to his good character when deciding whether the prosecution has satisfied you of the guilt. And I will tell you some more about good character. I wish to respectfully submit to your honors that even before getting to the good character direction, which appears to be given or attempting to be given in affirmative terms, that this particular passage has diluted the effect of the good character direction. Sorry, your honors.
So you say that direction was inadequate?
I'm saying that you can give a good, wherever a good character direction is required, that in giving the direction, it must be ensured that that direction is not diluted. I express it in that way because that passage comes before the passage dealing where the court deals with the issue of good character direction. I would, for the benefit of your honor, Madam Justice Lee, it would be page 20, page 40,
Thank you very much.
right?
So what number? 1440.
40.
Okay.
And in fact, your honors, if I may, when one looks at the discussion by the Court of Appeal in relation to the good character direction, if I may turn your honors to paragraph 60, in which the judgment says, for the respondent, Ms. Alexis Francis submitted that the trial judge properly directed the jury on both the credibility and propensity limbs, which directions were not undermined by the direction that being a lawyer did not make the appellant more or less credible than any other witness. Further, the judge had directed the jury in the following terms. Finally, having regard to what you know about this defendant, and in particular, the 9 years since the date of the alleged offense, and that no similar allegation has been made against him, you may think he is entitled to ask you to give whatever weight you think fit to his good character when deciding whether the prosecution.
Your complaint is that this idea that he is entitled to ask is a misframing, because there's nothing that he must ask for. He's
That is
entitled to benefit.
Yes,
And so that you say that sets up what comes to follow, and that is where the flaw is. The flaw is that it should have said he is entitled to,
he's entitled to.
not that he must ask you to consider.
That is correct.
That's the nub of your complaint, because even if everything that follows, that's what sets up,
Yes.
that's what the jury hears first, and therefore they start with this idea that he's asking for something when that is a misframe.
Yes.
Not asking for anything, he's entitled to it.
Yes,
That's your
ma'am.
criticism,
That
correct?
is my criticism.
Yep.
In
Go
a
ahead.
nutshell.
Good.
And I have the authorities, at least in the authorities, like Mustaq Kami, to support.
Is this a hard and fast rule, or is it that a court
No, it's
must
not a.
look at the whole thing in the round?
That is what I was coming to. In fact, this honorable court has made it absolutely clear that even if there may be a deficiency in the good character direction, it does not automatically mean an appeal will be allowed.
And what's the test?
The test must be that the evidence must be so overwhelming against the appellant that if the evidence is so overwhelming that the proviso can be applied even if there is a deficiency in the.
I have a feeling that you may have, I don't think we actually said it must be overwhelming. I think what we said, it must be sufficiently
Yes,
strong.
that's right.
Yes.
Sufficiently
It
strong.
must not be overwhelming.
Well,
but
I should
sufficient.
use the language of this court rather than the language of the Privy Council, because I think the Privy Council uses words like it must be overwhelming and strong. But I think that this court has said sufficiently strong. But in my respectful submission, I'm respectfully submitting that in this case, that the evidence could not be said to be so strong against the defendant, having regard to the fact that credibility in this case was of utmost importance. And so where credibility is of utmost importance, that the good character direction, I wish to respectfully submit, features falls.
But let's deal with the facts of this case. The police were on the scene at the time of the shooting,
Yes,
and presumably they would have been able to secure the premises. In other words, the persons who were involved in the fracas, so to speak, they were still on the scene. How many firearms were recovered?
one, may it please,
Who owned that firearm?
the appellant.
So isn't that strong circumstantial evidence?
But I wish to respectfully submit that this must be juxtaposed against the defense that he was advancing.
Against what?
Against the defense he was advancing.
The defense he was advancing was that Winsbert was approaching him with a firearm.
Yes,
And when you juxtapose the two, what do you come up with? No other gun was found. And the likelihood, given the scene at the time, is that if there was another gun, it would have been found.
as a matter of fact, there was evidence that the place was not properly lit.
Well,
So therefore, there's the possibility.
That doesn't help you.
Let us take that piece of evidence. If the place was not properly lit, how could the appellant see someone coming at him?
No, he said,
With a black handle
no, well,
object.
Your Honors, I wish to point out that that was the evidence that was placed before the jury. Now, I do not think that it would be far-fetched, even in a place like Spin Acres that he saw. I do not think that there's any evidence that the appellant is visually impaired. So I wish to respectfully submit. He was able to, because he was acting instantaneously. A man looks at said, "Harris Winsbot, this is the man who I was in bad blood with." When he turns around, he sees him coming, and he says, "What appears to be a firearm." So the peremptory strike. Preemptive strike, right?
So the defense is not necessarily that he saw a firearm, but that he formed an impression
And honestly believed.
and honestly believed that he was coming at him, felt under threat, hence drew his licensed firearm and responded.
Yes, ma'am.
So your position is that is uncontradicted evidence.
Uncontroverted evidence. Yes, ma'am.
And the only other evidence in the case is, well, if hostile witnesses go by the board, they say nothing in effect, is evidence of somebody who, and it's a negative statement, never said that they didn't see. It's a negative, it's right?
Yes.
And so therefore you say that when you put that in the balance, this is a finely balanced matter. Credibility makes a difference.
Yes.
I.e., whether we believe the accused, his credibility, that he genuinely and honestly apprehended perceived what he claimed, and that this nuance of he's entitled to versus he is the beneficiary of could affect the weighing of the scales in the jury's mind
Correct, ma'am.
to his prejudice.
Yeah,
Because
correct.
it is so finely balanced, you see.
Yes.
Yeah, all right. I understand what you say. And I suppose you would go further to say, therefore, just to complete that conversation, maybe, that in those circumstances, a reasonable court could not say that the jury would inevitably have returned the same verdict.
That is just what I was coming to.
Because if they accepted on a credibility basis that this is what he apprehended, then they could have reasonably come to a different verdict.
Yes.
Yeah, okay, good. I get it. That doesn't mean I agree. I understand what you're saying.
No, I'm not saying that you agree. I think I was trying to make the court, hopefully, make the court understand what I was saying.
Thank you.
Not that it necessarily accept it.
Yes, is there any other ground of appeal?
Millard, I think that would be the two grounds. That would be the grounds that would be pursuing, because when I look at the other grounds that I intended to pursue, they seem to have been kind of intermingled and it'd be the
Overlapping.
repetition of the same thing.
Yeah.
So in essence, that would be, I am hoping,
I think you're still within that.
yes, His Honor, in fact, alerted me at the time, but thank the Lord, I'm like Caribbean Airlines, I get here on time. Thank you.
So just for the record, whatever else is in the written submissions, there are two grounds of appeal before us, the hostile witness and good character
Yes.
grounds. Yeah?
Yes,
Okay, good, thank you.
But you stand on those other submissions which are in writing.
yes,
Yes. We have your clear.
thank you.
Yes, thank you very much.
You want to use pursued I do.
Ms. Thompson?
Yes. Good morning, Your Honors.
Yes,
morning.
good morning.
Should it please this honorable court, the appellant has advanced 6 grounds and the respondent has prepared and filed written submissions in response, and we rest on those submissions. But permit me, Your Honors, to briefly and succinctly outline our response to each ground, and if the court so permits, to expound and clarify certain aspects of our written submissions. As it pertains to grounds 1 and 4, no case submission made by my learned friend, counsel for the appellant. The respondent submits that there was in fact sufficient evidence at the close of the prosecution's case for a tribunal of fact properly directed to arrive at a verdict of guilt. The prosecution's case hinged on direct evidence from Rita Delmar, who testified to witnessing the appellant shoot Winsbott, but who also maintained in that testimony that Winsbott was unarmed and he was not doing anything. The circumstantial evidence is also relevant. That is, the post-offense conduct of the appellant in terms of the fact that when the incident took place,
Just a minute, Rita said positively that the victim was unarmed. That was a positive statement in the evidence.
Yes, Your Honor, she did. The
You have
question
that
was
part
posed
of-
to her.
You have that part of the transcript?
Yes, please, Your Honor. If I may be permitted to display it
Yes,
for the
please.
court.
This is for Rita.
So there are 2 aspects of Ms. Demar's evidence that I wish to refer the Honorable Court to. So as Your Honors can see, the direct question
We'll get a little assistance right now. You just open the page and
My
we'll
apologies.
help you with that right now.
So as Your Honors can see, the question was put by the learned prosecutor. Now, at the time earlier you said you were there with your boyfriend in relation to you, where was Winsbott? Next to me. Next to you, did Winsbott do anything while he was next to you? And she answered, no, Your Honor.
Yes, she answered.
On the next page, the question was also put. And after the defendant went past you, from the time you were at the place, did you see him do anything? No. But more importantly, Your Honors, the question was posed. And whilst you were at that place, did you notice anything about Winsbott during the time he was at Spinners? And her response was, well, I'm seeing no amicable answer given, but I interpret that to mean no, Your Honor. And why that is important is the...
Wait.
Yes, please.
I'm at a loss. What does no amicable answer given mean as a question of the record?
I suppose the only thing I could submit, Your Honor, is that seems to be a typographical error, but we rely on the first word, which is no. It's not acceptable.
Miss Thompson.
Your Honor, so we rest on the no.
But Mr. Thompson,
You can't.
you cannot
Yes,
rest on the
I-
no like that.
Yes, yes, Your Honor.
Amicable means favorable, friendly. I find it a curious entry, to be honest.
Yes, please, Your Honor.
As you at the place,
The problem may be with amicable,
It may
So
be-
it may be that is a mistype for no understandable answer or no audible. That is what is often found in transcripts, no audible answer.
I am indeed guided, Your Honor. What I can indicate is it seems that the Court of Appeal had a similar position, that the evidence from Rita Demar is that she did not see Winsbott, she did not see notice anything about Winsbott during the time he was at Spinners. But why I submit that is very important.
No, but before you
Yes,
go on
please.
though, what does the judge say about that? The trial judge, in his directions, what does he say?
In his direction, he also indicated that according to the evidence of Rita Demar, Winsbott, she did not see Winsbott doing anything at that time. And he juxtaposed that with the aspect of her evidence where she testified that she also did not see him with anything in his hands.
Well, perhaps you could take us to that. That would
Section
be
of the
important.
summation? Yes.
No,
No,
I
no,
mean
no,
the
the evidence.
evidence, the evidence.
Now, in just to understand, while you look for this, or your junior finds it, so that the setup is that she is next to him
That's correct.
on the scene,
That's correct, Your Honor.
right? And that is, she remains next to him when the shooting occurs.
That is our,
What is the evidence? Just instead, I know you want to take us to something specific. I'm just trying to. Could you just capture for us, for me maybe, in a summary, what is her direct evidence about sort of what happened? Because the accused's position is that he is told by someone to turn 180 degrees. He turns and he sees something.
Yes.
What does he see? He sees the victim approaching him, correct?
according to the accused.
Right.
Yes,
so,
Your
so,
Honor.
right. So that's one scenario. One scenario is that Elizabeth is not stationary, correct? Moving towards him with at least one hand, it appears outstretched. Is that accurate? That's what the accused says. Is that accurate?
That is accurate, except, Your Honor, on a careful perusal of his evidence. He did, in fact, give evidence on oath, not that he appeared or believed that Winsbott had a firearm. He actually indicated in his sworn testimony that he told the police that he attacked him with a gun. So I believe that's a little bit different. The other thing I wanted to
No.
Yes,
Sorry.
please.
I'm just trying to get a picture in my mind because you've read the transcript of what is playing out. So he turns, he says he sees somebody coming towards him, correct?
That is correct, Your Honor.
Now, but this person, Rita, is there next to the victim, correct?
According to her, but not according to him.
No, I know that.
Yes.
So according to her, what does she say she saw? Juxtaposed with what he is saying. He is seeing movement, correct? Somebody coming towards him.
Yes.
Right. What
Your Honor.
is she saying that Winsbott is stationary, seated, standing, moving? What does she say?
She indicated simply, Your Honor, in response to the questions from the learned prosecutor, that Winsbott was not doing anything during the time that he was with her. So
And that time included the time of the shooting.
that is my submission, and that is my submission on the basis that in Winsbott's evidence himself, he indicated what time he arrived at Spinners and what time he was shot. So he indicated that he arrived around 12:30 a.m. He also indicated he was shot at 3:30 p.m. So we can use or glean, or the jury could have gleaned from that evidence that he was there for that 3-hour period of time. Juxtaposed with Rita Demar's evidence, she was with him during that time, and during that time, he was not doing anything. She gave evidence that on that day, yes. Oh, I'm guided. So I stand corrected, Your Honor. It was witness Lonnie Alexander who testified that Winsbott didn't have anything in his hand. Rita Demar merely testified that he was not doing anything during the time she was with him.
And do you have Lonnie Alexander's evidence?
We do have it, and I can provide it. We can display it now, and I will also upload to the portal a copy for this honorable court. So Lonnie Alexander was asked, did you see Winsbott with anything in his hand? Her response was no. Did anything happen to Winsbott while you were at Spinners? He got shot. Yes, please, Your Honor. So the prosecution...
Sorry, hold on. Oh, sorry, the first part, did you see Winsbott? All right, gotcha. Yes, all right.
Yes, Your Honor. So
The trial judge.
But hold on.
Don't go so fast. Don't go so
Yes,
fast.
because the trial judge directed on that. She actually said when she saw Winsbert, he didn't have anything in his hands.
Yes.
The trial judge told the jury that.
But Ms.
Yes, Your Honor.
Thompson, on the same page,
Didn't see anything in the defendant.
she says in response to the question, did you see the defendant with anything in his hand? And she says no. So really she saw nothing.
That is correct, Your Honor. This is one of the
So-
hostile witnesses.
Yeah, but I'm saying to you, it cannot operate in your favor, it seems to me, that she did not see Winsbert with anything in his hand. She saw nobody with nothing in their hand.
I'm guided,
Anyway.
Your Honor, by
And the
that.
trial judge makes that clear as well in her submission.
That
Because
his
according
submission,
to
that's
her,
correct.
she did not see the defendant
Yes.
with anything in his hands.
Yes. So the probative value, I concede, is minimal, at best.
Non-existent.
Yes, please. Yes, please, Your Honor. So, in any event, as it pertains to the no-case submission, we submit at the close of the prosecution's case, importantly, self-defense never arose. So there was no need for it to be negatived. And the reason why we submit self-defense never arose is because the appellant never gave an interview under caution, a statement under caution, which was tendered before the jury. Added to that, learned counsel for the appellant never cross-examined the witness or put to them anything that could raise the issue of self-defense. So at the close of the prosecution's case, it consisted of direct evidence from Rita Denmar and pieces of circumstantial evidence from the other witnesses. I mentioned the post-offense conduct, Your Honors. And what I mean by that is we have, again, uncontradicted evidence from police witnesses who were never cross-examined that soon after the shooting, the appellant was found in possession of a firearm. Not only that, he had to be subdued by police officers and almost restrained. They said he never indicated he was acting in self-defense. All he indicated to
But
them
Ms.
is...
Thompson,
Yes, please.
self-defense doesn't really matter to you at this stage.
Well, I thought, my lord, that one of the submissions of my learned friend was that the no-case submission ought to have been upheld because self-defense arose and it wasn't negative.
Happily, he did not devote any time to it before us.
I'm guided.
And quite frankly, if he had, I think we would have made the same comment to him.
I'm guided.
At the stage of the prosecution's case, the no-case submission will not succeed on the basis of self-defense unless a prosecution witness raises that and it is so overwhelming as to discredit the other prosecution witnesses. So, yeah,
I cannot agree more, Your Honor.
but
I
I'm
will move
glad.
on
Thank you.
to the next row. Hostile witness direction. We submit that the direction on hostile witness evidence taken as a whole could not have confused the jury as the learned trial judge on multiple occasions. In fact, I counted 6. I can highlight them all to the Honorable Court if you also desire. On 6 occasions at least, he made it clear to the jury that they could not rely on anything that the witnesses did not accept or could not recall, or could not recall. They could only rely on their oral testimony. As it pertains to ground 3, good character direction, we submit that the appellant, as a person of absolute good character, he rightfully received the benefit of a full good character direction on both limbs, credibility and propensity, and the direction was in no way diluted to affect the safety of the conviction. The reference to his position as a lawyer, I humbly submit to this honorable court, went in his favor. And I will get to that a little bit later in my submission, but I do, I must
Lawyers
say,
are reputed to be bad people.
irrationally so, members of the public, again, have the irrational perception that lawyers may be
Ms.
individuals
Thompson, let us not engage in whether it is rational or irrational.
of lack of credibility.
Yes.
But what I will say is I do find merit in the point that was raised with your brother that the wording that the learned trial judge had used prior to giving the good character direction, when he indicated it may be something you're entitled or something, the word entitled.
Entitled to us?
Yeah, entitled to ask, I agree. It is not the best framing. However, when viewed as a whole, it is not fatal because a full, good character direction was subsequently provided.
So did he come back? Did the trial judge come back to say anything about being entitled to us?
No.
Or that was a one-off statement?
That was it, Your Honor. And because it was a one-off statement, it ought not to be viewed in isolation. The summation.
Curiosity, Ms. Thompson.
Yes, Your Honor.
Did you ever look at, let's say, the bench book to see if that language occurs? I have not. But it sounds like a classical English formulation. And now, members of the jury, you are able to consider that such a person is entitled to ask you that
Yes.
sort of English formulation. I am not making any statement, you know. I'm just curious.
I believe.
It's a choice of language.
I believe, Your Honor, or I submit, Your Honor, in my humble opinion, the language employed during the good character direction, that is the correct language that ought to have been employed. And that direction would have been in conformity with the bench book, and that is what the Court of Appeal.
You mean that's the subsequent
The
passage?
subsequent, yes,
Can you,
please,
do
Your
you
Honor.
have it? Can you
Yes,
refer us to it?
that would be at page 222 of the bundle, lines 1 to 14.
You have a page at the top of the summation?
Yes, please, Your Honor. That will be page 40 at the top of the
Thank you.
summation. We will now proceed. Learned trial judge, I humbly submit at lines 1 to 14, provided a classic good character direction, and I did rely on the case of Hunter to support that position. We humbly submit no fault can be taken with that aspect of the summation, and as such, this ground ought to fail.
This satisfies the positive credibility.
Yes, please.
As well as the propensity benefit.
Yes, please, Your Honor. And I think what is most important are the words that you can see at line 3, that it is a positive feature for him, which you should, not may, entitled to, which you should take into account. And thereafter, it is for the jury to determine what weight they ought to attach. So I humbly submit the trial judge adopted a correct approach as it pertains to the good character direction, and no fault can be found, at least no fault that could be fatal. As it pertains to grounds, because I know I have limited time, Your Honors, as it pertains to grounds 5 and 6, self-defense.
Just a
Mr.
minute,
Thompson.
if you go along on that
Yes, please.
page, I think
Take your
it's
time.
line 1,
I'm
2,
guided.
3, 4, 5, 6, 7, 8, line 8.
Yes.
Says it reinforces the credibility direction. This is a matter to which you should pay particular attention, i.e. the benefit of the credibility, the
Yes,
good
please, Your
character.
Honor. And I humbly submit in light of that the fact that the learned trial judge used those words, this is a matter to which you should pay particular attention, I think is commendable in light of the fact that the
From a
defendant
fairness point of view, it weighs the scale, if anything, in favor, not against.
That is my submission, Your Honor.
Okay.
And he did stress that they should pay particular attention, which is correct, because the defendant did give evidence on oath, and his credibility was very much an issue.
Yeah.
Might I proceed, Your Honor?
Yes.
Grounds 5 and 6 was an attack on the issue of self-defense. We submit that at the close of the prosecution's case, and in particular, in light of what I submit was the detrimental testimony provided by the appellant, the evidence of self-defense at the close of the case itself, meaning the close of the defense case, was negative. Accordingly, yes, please.
Just stick a pin, I don't want to disturb you.
No.
But you say that the evidence, could you just direct us to that as well then?
The
The appellant's evidence, you say, yeah.
the record of appeal, but we do have it before the honorable court.
Yeah.
Why is this having the blue number on the top? Why is this having page 2? Why does it have the blue number? It's not.
Curious.
That's all in the record.
This was a special meeting.
Oh, no. I think they're going to substitute. This is not what they will refer to.
No, this is something.
Yeah.
This is something.
It is.
The transcript. You mean here?
No, online. No,
It's
Eastern
on.
Caribbean.
It's on.
There were some breaks in the appellant's evidence dealing with legal issues. In my opinion, what is particularly detrimental were the inconsistencies which arose during the appellant's evidence. In terms of the material type,
Touching.
the
Even
appellant
touching.
indicated that he established that on that day, around, he was in Robbie Bay.
What page is that of the?
This is page 64. It's not part of
That's all right.
page 64 of the transcripts.
Whose evidence is this? This is the.
Appellant
Yeah.
himself, Your Honor. So is incident at failed begins at page 66 of that record of appeal. So the appellant does indicate that he went to the location. He was with some officers. He was waiting by a parking area for another officer. And material part will be at page 6. He indicates he's there at Spinners. He saw them suddenly stand up, some group of men who were seated by the bar. I saw them suddenly stand up. By the name of Barney, shouted to me, watch out, make up what I'm trying to get you to fight. I turned around instinctively with my back was facing the entrance. And when I turned around, I saw Windsor Alexander running towards me with his hand outstretched with an object in it, back-handed silver end. It appeared to me to be a firearm. I'm a holder with a holder of a licensed firearm. He retrieved my firearm from my holster in the waist, and I fired one shot to the right side of the body to stop it. The advance of Windsor Alexander. The advance of Windsor Alexander fell. And I immediately went straight back to the entrance of the police room where I had left Sergeant Curley and the officers. This is the important part I submitted. One of the important parts. I met Officer Matlin. He asked me whether I had shot the guy. I said to him, I didn't do anything wrong. The guy was the one who attacked me with the gun, so I defended myself. That was his version of it. Now, the other aspect that I submit that is detrimental is, I'll explain why, is with cross-examination. On the face of it, it seems that nothing positive arose. Look at it carefully, Your Honor. One of the questions I was asked.
Speak into the microphone just so we have.
Sorry. On the face of it, it appears that in cross-examination of the appellant, no probative, there was no probative value of his evidence, but on a careful perusal of it, in cross-examination, he conceded, that he and Lonnie Alexander were on good terms. Now, why I humbly submit that aspect of the evidence was to his detriment. The appellant being the only witness who raises self-defense, his credibility is an issue. And there were inconsistencies in that. Lonnie Alexander indicated that she not only saw him, but they spoke that night. When you look at that and try to reconcile it with the appellant testifying to the jury that he and Lonnie Alexander were on good terms, the jury would be very much entitled to ask themselves the question, why would the appellant lie about seeing Lonnie if they were on good terms? We also...
I've lost you.
Yes, please. So some of the inconsistencies in the appellant's testimony, when viewed or compared with the evidence of the prosecution witnesses, I submit, destroyed his credibility, which would have
What is
taken...
the inconsistency to which you're referring here?
The first inconsistency, I would say, is the issue as it pertains to his post-offense conduct. The appellant is saying immediately after, he told the police he was defending himself and the Winsbutt attacked him with a gun. The police, who were never cross-examined, denied that. They said that never happened. The appellant, in his testimony, said he didn't see any of the witnesses that night. Rita, Lonnie, all of the witnesses, or some of the witnesses, I would say, confirmed that they saw the appellant there that night.
He positively said he did not see Lonnie.
He said he did not see Lonnie. And Lonnie is saying not only did he see her, they spoke and that they were in the vicinity of the other civilian witnesses. We also have the aspect...
Just a second.
Yes, please.
I would prefer if we could see this evidence as distinct from you telling us.
And Ms. Thompson, it may help you if you were to refer the court to the fact that in the Court of Appeal judgment, there is a lovely summary of this evidence, including the particular piece of which you're speaking at paragraph 10
Yes.
of the Court of Appeal judgment, which is at page 15 of the CCJ record. So the appellant denied shooting Winsbury after he came between Loney and him, preventing him from getting to Loney. He maintained that he did not see Loney as Spinners and could not have grabbed her hand, etc. So it is all laid out for you.
That is indeed correct. The respondent does also rely on the summary of the evidence as contained within the Court of Appeal judgment. In the transcript, my learned colleague has just displayed one of the aspects. The appellant testified, I didn't see Miss Jennifer that night, I didn't see Lonnie, I didn't see Jennifer, I didn't see Cindy.
Page is that, please?
This is page 77 of the transcript, which again I will provide to this honorable court after. And apart from that, we also have the fact that, again, the inconsistencies with what the officer said, the inconsistencies with Lonnie, and what the appellant said as it pertains to his lighting conditions, the lighting conditions at the time. I will find that section for the honorable court. At page 70 of the proceedings.
This is his evidence. Yeah.
That's correct, Your Honor. It is his evidence, lines 4 to 7. When asked about the lighting conditions and what was the lighting condition there in the area where you saw Winsbury Alexander with the object in his hand, the appellant responded, it wasn't very well lit, because when I turned facing, when the guy told me to turn around, when I turned around, the person was coming from the dark area where the main activity was going on. So the light wasn't very clear. I submit all of that the jury could have taken into account to completely disbelieve the appellant's version or version of self-defense or defense of self-defense. And I think that is compounded by the fact that the appellant...
Mr. Austin, I've gotten a lot. Why are you... Okay, so that there are inconsistencies. What ground of appeal are you receiving? We're under self-defense, right?
Yes, we are under self-defense.
But what was the ground of appeal under self-defense?
It was, and I'm quoting from page 2 of the bundle. The Court of Appeal erred in law when it totally disregarded the appellant's argument in the written submissions that the appellant advanced a defense of self-defense which was not negatived or rebutted by the prosecution. Thereby, the appellant suffered a miscarriage of justice. As a result, the verdict was unreasonable.
And your response to that is,
The
from the
evidence-
record,
Yes, please.
the transcript of evidence, there is evidence of inconsistencies which the jury could have taken into account in assessing this defense of self-defense.
Precisely, Your Honor.
Yeah.
And the last thing I wanted to say on that point was that the appellant himself also introduced the evidence of bad blood between himself and Winsbott, that there was an altercation, or I know the Honorable Court would not be apprised of that evidence. I will.
No, it is.
It's in the
I'm guided.
Court of Appeal.
And that background evidence is also something that the jury could have taken into account to disbelieve the appellant's version of self-defense. This is a case, Your Honors, where self-defense only arose from one person, the appellant. Thus, once the jury or the appellant was sufficiently discredited, there was nothing else that the prosecution had to do to negative that self-defense. It would have been different, Your Honors, I submit, if there were other civilian witnesses who gave evidence of seeing Winsbott charging the appellant or having something that appeared to be a firearm. If that arose on the prosecution's case through cross-examination of our witnesses, or on the appellant's case through his presentation of
But Ms.
witnesses.
Thompson, I'm
Yes,
curious here. Why are you going on about self-defense? Because I think the only criticism which may have been made was that it was not treated properly by the Court of Appeal. I think that may be what was said. But the merits of self-defense is not an issue. And the rejection of it by the jury is not an issue.
Respectfully, Your Honor, it was a noted ground of appeal, so I thought I was duty-bound to respond to it unless...
But what was the ground of appeal?
The ground of appeal is that the Court of Appeal erred when it totally disregarded...
Right, so that's it.
Yes, please.
So to my mind, don't bother
I'm
about
guided.
arguing the merits of the self-defense.
I'm guided.
Yeah.
I'm guided, Your Honor. As it pertains to the argument about the evidence of Winsbott Alexander being elevated, we humbly submit that the effect, and if my learned colleague could go to page 204 of the bundle, lines 13 to 19, that we submit the learned trial judge did not elevate the evidence of Winsbott Alexander. The effect of the statement does not mean that Winsbott's evidence is untrue or that Winsbott attacked the defendant is insubstantial. Other references were made throughout the summation, clearly reminding the jury that they could not rely on the previous statement of the hostile witness. Furthermore, specific mention was made about the evidence of Winsbott Alexander himself and how the jury ought to deal with it. And this section is in reference to Winsbott Alexander's evidence. So the jury would have been very clear, I humbly submit, as to how to consider that evidence of Winsbott Alexander. We also submit, Your Honor, that an argument was advanced by my learned friend. According to the filed submissions, that the section of the direction where the learned trial judge said, alternatively, you may form the view that their statement represents their recollection at a time when the events were fresher in their mind. Although not ideal, we admit, it could not have operated to convey in the minds of the jury that they could have acted on those previous statements. It was made plain to them again, while not ideal, I submit by stating it merely represents their recollection at a time when the events were fresher in their mind. Frankly, Your Honors, yes, taken in isolation, it could tempt the jury to improperly rely on that evidence, just simply on the fact that the witnesses before them said they cannot recall, and they indicated the statement was given at a time that it was fresh in their mind. I concede that taken in isolation, it is problematic. However, that statement of the learned trial judge was a mere recitation of the evidence that the witnesses admitted. The statement was given at the time it was fresh in their mind. Nothing more and nothing less. The summation must be viewed as a whole, Your Honors, in order to appreciate the effect and the spirit of the directions. So while certain portions appear problematic in terms of the hostile witness testimony, the overall effect was to emphasize to the jury that they could not rely on anything that the witness did not accept or said they could not recall. And the respondent, we humbly submit that the evidence itself was of little to no probative value. So even if they did, it would not have altered the verdict or resulted in a fatal error. On that note, I also wish to submit, Your Honors, that when it comes to hostile witness applications and how to consider and assess that evidence, it typically varies from case to case. It is a dynamic area of the law, and how a jury or to assess the weight to be attached is all dependent on the evidence, what the witnesses says in their response. And I wish to emphasize to this honorable court that this is one of those cases that I submit the statements were not properly proved. The witnesses did not say, the hostile witnesses, that the statements were read over to them. They said it was true and correct. It was given at a time when...
Thompson, why are you spending time on that? Let me tell you, when this question as to what weight
Yes.
you are to give to the previous statement of a hostile witness, that is when the hostile witness is a person who gave a statement saying ABC in their written statement, their police statement, and come to court and say X, Y, Z, directly contrary or varying from ABC. Yes. This is not the case here. They came to court and said, I cannot remember stating A, B, and C. I am stating nothing. Done. So there is not any contradiction. It is not a question of choosing between what they said then, when the thing was fresh in their mind, and what they are saying now. No issue arises at all in relation to it. And it seems to me that the judge may have been letting his peeve, understandable peeve, come out there, where he says, it's remarkable, isn't it? When, when matters were fresh in their mind, they gave a statement. Now they come here and say they can't remember anything, even after they have read over the statements which were given to them.
Yes.
That is what he was doing. Yeah?
I agree precisely, Your Honor.
But the statements, as you say, were never put before the jury. The jury were told, it is not evidence. If it had been evidence, the statement would be put before you, therefore, forget it. Yeah?
I agree 100%.
There we
Your
go.
Honor,
Ms. Thompson,
and I will
Ms.
take it
Thompson,
a bit further.
can I just ask
Sorry,
you,
Your Honor.
before you go any further, on page 204, is there any part of the transcript where the prosecutor read to the witness what was said in the earlier statement, and the witness then said, I can't recall?
Yes, Your Honor, I was about to get to that point.
So is it then that the record shows that all of the evidence in the witness statement of the victim was read to the witness in the box, and then the witness said what is stated at 204?
Not everything from the witness statement.
But the
The
implicating part.
implicating parts. That is indeed correct. It was put to the witnesses.
So this is page 204. I assume that came before 204?
That evidence, my lord, would be a part of the transcript of the proceedings.
This is not the,
against
yeah, but
This
don't
is
you
the
have the
submission.
transcript with you? So I just want to get a sense then, so that the jury
Yes.
heard, read to the witness what the witness said in their earliest, well, let's deal with the victim. In the victim's earlier statement, is that what happened?
Yes, the incriminatory parts were put to the witnesses. Yes.
And then they said, I don't remember, all I remember is getting shot, that's it, yes?
That is correct.
So
Your
the
Honor.
jury heard that evidence
That is correct.
of
Your Honor.
what they had in the judge's remarks said earlier,
Yes.
when it would have been clearer, and have now forgotten.
That is correct, Your Honor. So my learned colleague,
And would that have been true for all the witnesses or just for the victim?
that is true for all of the hostile witnesses.
They were asked specific things that they allegedly said?
That is correct
I see.
from the statement.
Okay.
But what I wish to submit.
No.
Yes, please.
Before you submit in here, can I just see with the victim's statement what the jury heard
Yes.
about what was in the victim's written statement?
Yes, Your Honor. It begins, Your Honors, at page 39 of the transcripts. This is after Winsbott Alexander was deemed a hostile witness. It was first put, is it not correct, Mr. Alexander, that on the 8th of June 2012, you gave a statement to the police? I can't recall. And that statement was taken at Tapion Hospital? I can't recall. And you gave that statement to Corporal 622 Jawahir? I can't recall. In that statement, you told Officer Jawahir what had happened at Spinners on Thursday, the 7th of June, 2012. No, I can't recall. And in that statement, you told Officer Jawahir that the defendant, Marius Wilson, shot you. I can't recall, sir. It goes further. I'm putting it to you that on the 8th of June, after you gave Officer Jawahir your statement, you signed on the form that you wrote the statement. I can't recall that, sir. And I'm putting it to you that the writing you saw in the statement earlier is your handwriting. I can't recall that. I'm putting it to you that you also told Officer Jawahir in the statement that you are very certain that it was the defendant who shot you. Answer, I can't recall that. Goes on. Yes. In this court today, you told us that you got shot at Spinners about 3:15 a.m. on Thursday, the 7th of June, 2012. Yes, sir. What were you doing at that time? I was in the crowd. It was an activity that was there. Question. I want you to tell us, what were you doing at the time you got shot? To recall.
All of this was before the Court of Appeal, right? Yeah.
All of this.
This transcript, the Court of Appeal had sight of this. That's why in their judgment they've written what they've written.
That is indeed correct, Your Honor.
Okay. So this is the record from the Court of Appeal, because this is a bound document that we're seeing. This was before the Court of Appeal.
That is
But
correct,
you just
Your
didn't
Honor.
place it before us.
Yes, we bounded
Okay.
ourselves,
I
but
see,
this was
okay.
part of the transcript, the record of appeal in the lower court.
Before the Court of Appeal.
That is correct.
Okay.
And after that, Your Honor,
Can you just turn back that page? Let me see something. You told the police,
Your Honor,
I'm very certain that Marius was going to shot me. Yeah. But sir, I can't recall. I
Well,
read
I
that.
can't
I read
recall
it, but I can't recall. I tell you. All right. Okay. Good.
Yes.
All right. And it continues like that.
It continues like that, essentially, Your Honor. If I may be permitted, and there was no cross-examination, if I may be permitted to now take the Honorable Court to the other hostile witness to just illustrate what was put to that witness. That is witness Jennifer
But
Dujon.
sorry, to what point?
I thought, Your Honor, wanted to see what was put to all of the witnesses.
No. I
No.
was interested with the victim, but I gather that this has been repeated with all.
Yes,
And
it
we will
was.
get this in due course,
Yes.
apparently.
What I wish to submit on that point is because of the fact that in this case, the previous witness statements were not properly proved. And I say that in the sense that the witnesses never indicated, again, it was read over to them, fresh in their mind, they said it was true and correct, and they signed it. Moreover, the police officer who recorded the statement was not called as a witness.
Ms. Thompson, you don't need to go there. The
Yes.
statements were not produced to the court. So the question whether they were properly proved
Right.
would relate only to if they are being cross-examined in court about a previous statement that they made inconsistent with their present testimony, and therefore you want to say you are lying because you gave this statement, you wrote it, you signed it before PC so on and so on. We called PC so on and so on to say, so all of that is
I
unnecessary.
agree with Your Honor. I
Well, I'm
think
glad.
the larger point that I'm trying to make is in the absence of the statement being properly proved, it is unlikely, actually, it is unfathomable that the jury, being sensible individuals, we have to give them credit,
Right.
would have relied on that for the truth of it. Because the
Ms.
witnesses
Thompson,
never
let's
said it
not
was true.
overstate matters. I think we can have a fair idea that it may have occurred to the prosecutor. Okay, I can't get the statement in, but watch me.
Yes.
I will put to them what we all know they said, which they now deny.
Yes.
I will get that before the jury, and the judge can direct, as he properly did. Do not regard, as the judge said, the questions, have regard to the answers. So the judge can direct them all they want, but I, prosecutor, will give the jury a taste of what it is that they said earlier, and they can choose to follow the direction of law in relation to this, or they can choose to decide, okay, we know what happened, so the judge can say what he wants.
I
Yeah?
do understand that.
Yes,
Your Honor.
thanks.
The last thing I will say on that is I think I submit that there would have been more merit in the appellant's argument had those statements been properly proved. That's what I would submit on that point. I do not know if Your Honors had any specific questions for me. We do rest on our filed legal submissions. In terms of clarification, Your Honors would have seen that I had cited an Australian authority of the Queen and Adams. And my learned friend, counsel for the appellant, in his response had indicated that Adams is not good law in St. Lucia. What I would indicate is, based on the fact that I accept that the previous statements were not properly proved, Adams, I still submit as good law, but would not apply in this case. So I do withdraw that argument at page, written submission. I withdraw that argument simply on the basis that the statement was not properly proved. And that is a requirement in order for that authority of the Queen and Adams to apply. So, Your Honors, the respondent respectfully submits that, again, based on our written submissions and our oral submissions, that all of the grounds of appeal ought to fail in this case, and we humbly submit that the grounds are without merit, and as such, the appeal against conviction ought to be dismissed. Unless I can be of further assistance and answer any other questions that this most honorable court has, those are the submissions of the respondent.
Yes, thank you, Ms. Thompson.
Do Your Honors wish for me to electronically upload?
Yes, we want you to file them in these proceedings.
I'm guided. I will try to upload them as soon as possible.
Yes. Mr. Richelieu, do you have any reply?
Mr. Richelieu, if I may tease you, don't feel compelled, you know. You seem reluctant to come forward.
That there is much that I need to add in this particular matter, except that I would like to report on the direction by the trial judge in relation to as to whether the person was entitled to ask. That I cited in my submissions the case of Mustaqim at paragraph 10, which would be of assistance in terms of, is the case of Queen and Mustaqim, a 2008 EWCA Prim 3096 at paragraph 10, and that would be able to assist in terms of the justice of the case as to how.
Sorry, you said it's in your submission at where?
Yes, yes, ma'am.
At what?
Mustaqim.
Yeah, what paragraph in your submissions?
Page 436 of the record.
436.
And could you summarize in a short sentence what is the point in the case? We can look at it, yes, but what you bring it to our attention
In
because
essence, sir, the contention is that because evidence of good character is of probative significance, that it should be advanced as a matter of law and not as a matter of argument.
Not as a matter of.
In other words, when the learned judge said, you think, in terms of whether you think that she,
you may
I'm asking you
feel
to rely
entitled to ask
as if you
whether.
should be asking to accept an argument rather than it being an objective fact that will be taken into account.
Well, sorry, the case again is, what's the name?
Al Mustaqim, Moustakim, a 2008.
Page 436 of our record.
Okay. Thank you.
Can I be excused, please?
That's
Yeah,
it?
that's it.
That's it, my comments. Thank you very much.
Okay. We will rise for 10 minutes and then we will let you know how we propose to proceed in this matter.
All right.
Ms. Thompson, how much time would you require to file those documents?
I uploaded it already, Your
You've
Honor, so
uploaded
it should
it?
be filed momentarily.
I see, okay. We will take time to give the decision, and we will let you know when we will be ready with it.
Much obliged, Your Honor.
Much obliged, Your Honor.
Madam Registrar Acting, can you please close the proceedings?
Thank you, President Saunders. Thank you, Madam Justice Rajnathi. Thank you, Mr. Justice Barrow. Thank you, Mr. Burgess, and thank you, Mr. Justice Jamala. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
All right.